Well, accused number 2, Bongani Ntanzi's alleged confession, again a bone of contention. Well, the state says Ntanzi's alleged admission, which was recorded, should be admitted as evidence, as the audio sound is merely what Ntanzi was already relaying to witness Magistrate Vivian Cronje.
What is the state's view about the invasion, the alleged invasion of the privacy of accused number 2, is it? When you make the tape recording, is his constitutional right in terms of section 14 of the Constitution infringed in that his privacy has been invaded by such taping?
Well, my Lord, would submit that in this instance, the recording is the electronic version of what the accused was telling the magistrate. So we submit that there's no room to argue that his privacy was infringed. He was in front of a magistrate, making a statement in terms of section 217, and all that the magistrate did, my Lord, was just to keep a record.
But the defense argues it was unlawful to record Ntanzi without his consent, that it was unconstitutionally obtained, and that Ntanzi's rights ought to have been explained to him prior to the recording, and that audio would be used against him in court.
The legal question here would be, was the recording per se obtained in a rightful way? What does section 35 says? It provides that evidence obtained in a manner that violates any right in the Bill of Rights must be excluded if the admission of that evidence would render the trial unfair. How was it obtained? It was only the person who took it that she knew that she was taking evidence without the knowledge of the declarant. So, in essence, such evidence, it is my submission that it should be excluded.
Yes.
These tape recordings should be excluded in the circumstances that they will definitely violate the rights that are enshrined in the Bill of Rights or the administration of justice.
Above meeting the requirements, if they were met, of section 217, the magistrate who is the witness ought to have explained the constitutional rights of the accused specific to the recording, to say that above what I will be recording, what I will be taking down in the statement, in the document, I will also be recording, and the voice recording will be used in court against you. Yeah. Those constitutional rights, my Lord, I submit that they ought to have been explained to the accused or to the deponent at that time before he made or before the witness proceeded with the recording. Until such a ruling has been made by this court, the video recording, which was unconstitutionally obtained in terms of section 35(5), should not be played to the court because it contains incriminating evidence.
Judgment will be handed down on Friday. Criselda Lewis, SABC News at the High Court in Pretoria.